Lord have mercy. The Lord is my shepherd. He know what I want.
There's no nobility in poverty. I have been a rich man and I have been a poor man, and I choose rich every fucking time. Because at least as a rich man, when I have to face my problems, I show up in the back of a limo wearing a $2,000 suit and a $40,000 gold fucking watch.
You didn't put in on this, man.
Better get a receipt, my brother.
So y'all can see my screen. Damn technology. Mic check. Mic check. 1 2 1 2. Blame it on the weed. So look, I really wanted to show y'all this video, but this stuff is lagging. I don't want to show you guys, because I need y'all to hear and see this in real time. So look, I really wanted to show y'all this video. And it sounds like y'all can hear me good. So let me try it. Now, I'm going to put the link in the chat again. Check it out. I updated it. Everything I'm about to show you, peace and love to everybody. We got gold and silver in the building. We got Beer Gang Tabernacle in the building. We got J Fox, also known as Cars and Cool, in the building. We got everybody else joining on the Instagram family. The Instagram is Don_Kilam. The Facebook family is Ali Malik Kalam Bay, okay? If you're out there in those worlds, I'm holding a private class via private links via YouTube. And CC De Niro Bay is watching. Much peace and love. But look, leave a donation if you find this information of value. So I'm going to give y'all that dope today. All right. Now, yesterday, what we went over was my own dispute letter. My very own dispute letter that I start off for mortgages or even foreclosure. Now, there is another dispute letter that we utilize, right? I click that right here, foreclosure guide right here. Check the link in the chat, everybody. I'm putting the link back in the chat. You click that link, check it out. Click the link. Well, apologies. That's the wrong link. Let me grab the link. Where everybody should have access to the files. It keeps giving me the YouTube links. My apologies. 1 second, guys. Alright, now, yesterday, what we went. Boom, there we go. I'm going to remove those. That's the link to the class, alright? Now, there's a link to the files right there. So, where I'm going over, you go right here. It says foreclosure guide, right? Now, we're not going to go over, well, we might go over everything today. But I want you to know, this starts off, you can use this for your mortgages and foreclosures too, right? I'm not a licensed attorney or tax expert. We do this for educational, informational purposes only. So letter 1 is always to the banks, the mortgage companies, all right? It's always to the letters and the banks and the mortgage companies. And we already went over the dispute letter yesterday, okay? Now, this one is a claim and demand as the creditor. And you're filing a notice of claim and grievance, a resolution request, which is an administrative process. You always have to address the administrative issues first before you can get remedy from the higher ups, before you start assessing the actual tax. Alright? So this one's being sent to the banks, the CEOs of the mortgage company. We send them to the CEOs or the CFOs, the chief financial officers, right? You're going to need the alleged account number, the property address, if you have the tax ID or the property tax ID number, the search for the MERS number, the mortgage electronic registration system number, okay? And then which county it's in. You're filing this with the circuit court and the district courts, okay? And then if it's under foreclosure, the foreclosure number. And it states, I have discovered your habitual and extensive abuses with home loans and mortgage transactions associated with the above regarding with the information I absorbed. The following has come to my attention. The loan was personal. The note was never transferred to REMIC, which is the real estate mortgage invested conduit, which I showed you how to assess that tax with a Form 1066. Thus, it was not secured. I was an investor and I want my proceeds. The home was paid for with the mortgage default insurance, and I never abandoned my property. However, I rescind my consumer application due to unconscionable transactions per 12 CFR Part 1026 Regulation Z, subsection 15A2. Now you're in FTC and SEC fraud, which is Federal Trade Commission and Security Exchange Commission fraud, because they're securitizing these agreements. That's what we talked about yesterday. The MBSs, the mortgage-backed securities. They're turning notes into securities. That's what's going on, and you're the main investor. By reporting anything but debt is paid in full, you are open to lawsuit under the FDCPA. I'm the depositor and true creditor for this account. Therefore, you never risk any of your assets at any time, and you fail to provide disclosure. Instead of reporting your tax fraud and over 19 counts of Title 18 crimes to the proper authorities, exposing everyone involved to pay punitive, general, and exploratory damages and special damages regarding the unlawful foreclosure, it would be beneficial if you return the property, my investment, and damages you owe. This is a self-executing contract, and the co-respondents voluntarily agree to report their account in the above regarding to all credit bureaus as paid as agreed, and reconvey the property to the claimant and compensate claimant damages in the amount of whatever you choose, or troy ounce in silver by certified mail within 30 days from the date on the notice. And if they don't, on the Facebook shut off, huh?
They did?
Yeah. They be doing that sometimes. They don't want this information out. Now look, if they don't respond to this shit, which they won't, they can't. I'm gonna show you there's the next step, because we're still assessing the tax. Now, I give them like 10 days, but some people give them like 21 days, okay? I give them like 10 days. Now, the next step is the notice of insurance violation pursuant to 12 U.S.C. 1709, sections 9C, insurance and mortgages, and 12 U.S.C. 3017, section C, bonds, debentures, notes, and other evidences of indebtedness. That's with the Department of Treasury and the FDIC, because they have insurance. FDIC insurance, all right? So, they're liable. You know, there's rules they have to follow because they have the insurance. Then the REMIC fraud report with the SEC. And then we assess the tax with the IRS, the Criminal Investigation Division, or the Contract Investigations Division in D.C. With the IRS forms, the 1041, 1066, 1099A, and 1099 OID. And then your Secretary of State. You know, we're investigating the warranty deed, the deed of trust, the appointment of substitute trustee, because they use fraud, and they're using the notary to commit fraud. We're gonna apply for arrest warrants and offenses against the United States and equitable relief with the district courts, And then the investigation of the breach of oath, powers of attorney, securitization, voidable deed, and Title 18, Title 42 action violations with the Attorney General of your state with a grievance resolution request, a claim and grievance request. This is what we're doing starting off, just to jumpstart everything, okay? Just to jumpstart everything. Does that make sense to everybody? Peace and love, peace and love. So I'm putting that back in here. Does that make sense to everybody that's following along in the class? Now look, I want y'all to watch this video to understand what's really going on. I think it's this one right here. This is in the video for y'all.
In the car to one of the other patrons, jumped in his car, stepped on the accelerator rather than the brake, and he pinned these two patrons up against a nightclub. Well, one of them lost 2 legs and the other one lost 1 leg. I know it's a tragic story, but what we learn from this story is how lawsuits proceed. Because the plaintiffs, the 2 individuals who were injured, they sued the nightclub owner, they sued the valet company. Now, both of those individuals were able to settle for their insurance. But how about the property owner? I mean, if you ask this question to most people today, they would say, oh, the property owner is liable. But you ask that same question 25 years ago, people would say the property owner had nothing to do with the accident. Really, the only person who is liable is the driver of the car. But nobody wants him because he has no assets. He's in jail. But the property owner had his building in his own name. And in fact, the property owner had $20 million in real estate in his own name. So when it came time to settle, they looked at the property owner and they said, no, we're not going to settle for your insurance policy. We're going after you because you're a deep pocket defendant. And so that's what occurred. And the property owner ended up settling for a lot of money to make this case go away. Now you contrast that to the nightclub owner who is my client. The nightclub owner had all of his assets protected in various business entities. In fact, the way we had created that structure, you wouldn't even know that he owned the business entities. And I'm going to share with you how you can do that with your own structuring by setting up LLCs and choosing an anonymity compliant jurisdiction.
Gotta make sure everybody can hear and see. Can everybody hear and see? I want to make sure that everybody can hear and see the video of the class. Because what he's about to break down is truthfully what you need to know. Not only for to protect your property, your land, your real estate, or whatever it may have, but protect your whole estate or anything that you have of value. So I want to make sure that everybody could hear and see the video. So in the chat, let me know that you could actually hear and see the video. Robin says loud and clear. Alright, so I'm going back and I'm going to finish. It's about a half hour long, so get ready to take notes. I'll up and go back, but you have access to this video. I made sure you had access to this video.
So let's just start talking about this now. If you have rental real estate, the number one entity you want to use is a limited liability company. You don't want to use corporations because corporations create adverse tax consequences to you. I mean, I have real estate all throughout this country, and some things that I do on a periodic basis is shift assets around. Now, if I had that real estate inside of a corporation and I wanted to pull the real estate out, well, that would be a taxable event. That's why I stick with LLCs to own my real estate, to ensure that I can move assets in and out of those LLCs and not incur a taxable event. The other reason why we like limited liability companies is because they offer 2 forms of protection. They offer both inside protection and outside protection. And let me show you what I mean by that. So with inside protection, what we're concerned about, if this is your LLC, is that if you have a property here and you're down here and you own the limited liability company, and of course you will control it, if something happens on the inside here, we don't want this coming out and hitting us individually. That's the first form of protection that a limited liability. In fact, that's similar to corporations as well. But where corporations fall off and LLCs continue on is with outside protection, which is equally important and probably just as likely to result in a lawsuit as the inside protection. Outside protection is where you are the source of the lawsuit. You've done something. Your family has done something that brings liability. Depending on the state in which you live in, liability can be quite high for you. The example I just shared with you, that story, those individuals lived in California. And California is a joint and several liability state. That means that that property owner, he could have decided to fight that case. But the reason California, if the jury finds you're 1% negligent, then you're 100% liable for all of the damages. Just think how that could apply to you. If you're involved in a small car accident, or maybe it's not you at all, maybe you're hit from behind and you're propelled into another car. All they have to show is that you're 1% negligent and you're liable for all their damages. If all of your assets are in your own name, you're a deep pocket defendant. So we want to get those assets out of our name, our cash, our real estate, and put them into entities that provide us outside protection as well as inside protection. And that's what a limited liability company does. So if we sue you or somebody sues you and they get a judgment against you, let's say the judgment's entered against you for $300,000 and you have no assets in your name, then the question is, what do you own? Well, if you show that you own this interest in this limited liability company, the question then becomes, can they take it from you? Well, states are not uniform in this approach to asset protection. Some states, like California and others, allow the creditor to take that interest from you. So you would lose your LLC, and so goes your LLC, and so goes all your investments. Other states, like Nevada, Wyoming, Texas, they do not allow a creditor to take your interest because they limit the creditor to a charging order. And charging order simply means this, that if you have cash from your rents that have been building up inside of that LLC, and you decide to take a distribution. Remember, you decide because you're in control of this entity. If you decide to take a distribution, then that distribution has to go over here to pay off your creditor because he has a judgment against you. That's how a charging order works. It basically attaches as a lien to your interest. So when you take money out, you have to pay it to your creditor until your debt is paid off. Well, we know we're not going to take money out, and so do plaintiffs' attorneys. They know that when you set up entities in the proper jurisdiction and you have this type of control, you're not taking the money out of your LLC. So these LLCs will never pay off. And that is why when you use LLCs in the proper state, these types of people do not get sued. Well, actually, let me rephrase that. They get sued, but they don't get collected on. They always settle out because the plaintiff's attorneys know there's nothing for them at the end of the day. Similar to my story that I just shared with you with my client. The attorney on the other side realized that all he had at his disposal was the insurance, that everything else was protected, removed beyond his reach, and he was looking for a quick payday. And so he took the insurance rather than try to fight and not win anything at the end of the day. So asset protection with an LLC, two forms. We have inside, which is uniform in all 50 states, and we have outside. And you want to make it offers you outside protection. Why only have one when you can have two? And that's how you know when you're setting up a good limited liability company, it's a cornerstone to a great asset protection structure for rental real estate, one that provides both. And I'm going to show you how you can figure that out here in just a second. All right, let's clean this off. Now, when you're thinking about forming a limited liability company, the question always comes up, where do you set up your limited liability company? What state do you use? Now, I threw out there Wyoming and Nevada. Let's assume that I own property in Oregon. Would it make sense for me to set up an LLC in Nevada to own my Oregon property? You'd be surprised how many people actually make this mistake. They own property right here in Oregon, of Nevada and Wyoming. Let's go over here, create this Nevada LLC, and then have it own our Oregon property. Then we get all the protections of Nevada. Well, the problem is, if you set it up in this structure, let's assume you have a tenant that quits paying rent. What do? Most people would say, simple, Clint, you file an unlawful detainer action against them and you evict them. But the problem is that if you've set it up in this manner, you can't evict that tenant because your LLC is not registered to do business in Oregon. So you're basically an outlaw. So now the dilemma becomes, how do you effectively manage your property if you're not registered to do business there? You don't. So then you end up taking this Nevada LLC and registering it in Oregon to conduct business in order to own your rental real estate. Now, that brings up another issue. Some of those benefits that Nevada provides you, namely this: if you set up a Nevada or Wyoming entity, you can have anonymity with your entity. That is, we could set it up so that your name doesn't appear on it, so nobody knows that you own this entity. This is a cornerstone to an anonymity-compliant asset protection structure, making sure that if somebody performs an asset search on you, they don't know that you have assets because back to you. My partner, Toby Mathis, he and I started Anderson together. He's on over 17,000 entities in Nevada and Wyoming. That is, he serves as a nominee officer, director, or manager of these various entities. So if somebody's looking up the entity name, they see A.T. Mathis. Now you may be wondering, is Toby in control? Does he have any type of say over the business entities? Not at all. He resigns before we turn over the business entity. So he's off, our clients are in control, but nobody knows. Now, the first benefit then is anonymity. Second benefit is charging orders. Now this is something that a lot of people are looking for when they create a Nevada or Wyoming limited liability company, because they have some of the best charging order protections in the entire United States. The problem is both of these protections fall off as soon as that entity gets recognized in Oregon. That is, once you register to do business there, you lose those two protections. Nevada or Wyoming entities, do not tell real estate investors this, because they want to make money off you. And really, that's what we're doing here. When we create a structure, we use a Nevada LLC to register it in Oregon, or any other state for that matter, you end up paying double the filing fees. You end up compensating the person or the company that resides with a business address to provide you with resident agent, to provide you with anonymity. So you're paying this person for a service, for a benefit that you've lost as soon as you have filed it in Oregon. Don't make that mistake. So when it comes to setting up limited liability companies for rental real estate, we have an initial question we have to ask ourselves. And that question is, where is the property located? So I want to know where the property is located. I'm going to stick with Oregon here since we've already started talking about it. So let's assume that my property, again, is located in Oregon. All right. Now, ordinarily, what we might look at is, let's create a Oregon limited liability company. But we know whether or not Oregon offers two forms of protection. That is, does it offer inside protection and does it offer outside protection? Well, we look into it and we find out Oregon does not provide outside protection. So for this Oregon rental that we own, we know that if something happens with the tenant, we're protected, but what happens if we get sued? And it doesn't matter what state you live in. Let's assume that you live in Texas, but if you have an Oregon LLC and it doesn't provide charging order protections, then that would be exposed to your personal creditors in Texas. So if you want those outside protections, then what we're looking at is, where do we file? Well, we will file in Oregon. Well, I'll probably create an Oregon limited liability company, but an Oregon LLC personally, because if I'm sued, they can take it from me. So I want a buffer entity. So I'm going to choose a jurisdiction that provides charging order protections. I threw out there that I live in Texas. Texas provides charging orders. So if I created a Texas LLC right here, and I had it own my Oregon LLC, and then I own the Texas LLC, now I've achieved my goal. That is, if somebody sues me individually, I own a Texas LLC that offers charging order protections. Therefore, I don't own this Oregon LLC, so there's no relation between me and the Oregon limited liability company. So they had asked me in a deposition, Clint, what do you own? I own a Texas limited liability company. I don't own Oregon. Oregon's owned by the Texas LLC, so it protects those LLCs from their faulty charging order statutes. So this is how we get or obtain two forms of protection. We have to set up an LLC in a charging order protected state like Texas. Now, I did that because I lived in Texas, and I wanted to then further this example by considering what happens if you want anonymity. Now, Texas does not provide anonymity, so we cannot, or that is, if we were looking for anonymity, we can't use a nominee like A.T. Mathis in Texas to serve as our initial manager of our limited liability company, because as soon as he is replaced by you, that information has to be submitted to Texas Secretary of State, and your name pops right up there. So now the question becomes, Do we set this up in Texas or do we set it up in another state? Well, I've worked with thousands of clients, and those clients that desire an anonymity compliant structure, that is one where you cannot trace back any of their assets back to them, we start with either Nevada or Wyoming. So rather than go with Texas here, we end up setting up this entity. Let's say we're going to go Wyoming. Now, by creating this in Wyoming, again, this has to be the first entity you create before you even start here, because once your information is out here, game's over. We can't do anything. We can't reverse it. Once the horses left the barn, there's no bringing them back in. So if we start with Wyoming and we use A.T. Mathis on there, so you have anonymity, then I will go into Oregon and set up my Oregon LLC. And when I do my filing, there's a very important step, member managed LLC. Then you have to list the members. Now, you probably catch where I'm going with this. If I file this as a member-managed LLC, and I have my Wyoming LLC as its member, what happens? Well, when you file this LLC in that LLC, you're going to say, well, it's my Wyoming limited liability company. So this entity will point to this entity, and this entity will then in turn point to this guy over here, which is A.T. Mathis. So it'll all point to him. You, no one is going to know about, because it's kept your information private through this anonymity compliant structure that we're creating. So when you go about creating your limited liability companies, you really have to understand member managed versus manager managed, the inside versus the outside protection that your state provides to ensure that you're getting the best overall protection afford for your particular assets. Now, after we've set up these entities, the next thing you have to decide is how are you going to have them taxed? Because that's equally important. Just the other day,
let me know that it's all making sense right now. Let me know. But that is making sense. It makes sense. Make sure you hit like too. But let me know that it's making sense. And I'm going to keep pushing forward. Everybody's saying yes, yes, it's a powerful man. Sweet deal. It's important to understand what's going on, especially with the LLC structure. And staying. This works for any assets, not just your property. Any assets. But it definitely works great for houses and land, okay? You got access to the video. Click the link. There's the link. Boom. Yes, it's complex but simple. That's what Jay Fox said. Cars are cool. I'm going to keep pushing. Because you got to know what to do. Once you get access to your land, you need to know what to do with it. So, once you get the land reconveyed, you need to understand what's going on. You get this mortgage. You learn how to offset it. You learn how to reconvey the land. You learn how to reconvey the deeds. Offset the mortgage, assess the tax, right? You're going to need to know what to do with the actual, how to set it up and keep it private and keep it from people, keep it from creditors or anybody that's trying to access it or claim you owe them something. Company. It's really that simple.
I dealt with an email from someone who did not understand the difference between taxation and state law. You can choose how you want to have it taxed. That's a unique aspect of an LLC. The federal government states that once you've set it up, you can elect to have it taxed as a C corporation. You can have it taxed as an S corporation. You can have it taxed as a partnership if there are at least 2 members in your LLC. Or you can have it treated as a disregarded entity. Now, a disregarded entity is an entity that does not have to file a tax return. Everything reports down to the individual member's personal tax return. So, and it's a disregarded LLC, and this person owns it, then any income here will show up on this person's 1040. How about if it's a married couple thing? You can have 2 members and still treat it as a disregarded entity provided they're a married couple. So everything that here will flow up on their 1040. This entity, this LLC, will not have to file a tax return if it's a disregarded entity. Now, if it's a partnership, if it's set up as a partnership, then we don't have to worry about that. When you set up your entity as a partnership, because we have 2 partners here, then this entity is going to file a 1065 tax return. So it depends on how you choose or how you elect to treat that entity for federal tax purposes will depend on where the income shows up. 1065 is going to give a K1 that's going to flow down on the individual's tax return. They'll report that income on their return on their 1040, but you have to file 2 returns in this example. Now, going back to that disregarded structure again, I showed you 2 individuals there owning it. How about if we did this? How about if I created an entity down here, and maybe this is that Wyoming LLC we're talking about. You're setting up the $35 a month. If you're a real estate investor, I encourage you to look into this program. She signed up for the program and she brought in 2 limited liability companies another group had established for her, and they were 7 pages long. She says, what do you think? I looked at them. I said, these aren't even juvenile operating agreements. They're infantile in their creation. Literally, I couldn't be any more blunt than that. They were not set up as LLCs. Although they were companies, they offered her 0 protection. If she stuck with those limited liability companies and she was involved in a lawsuit, all bets are off. She might as well own the properties in her own name. So this is a very important aspect of creating these types of structures, making sure that your operating agreement provides you all the necessary protections. Now, back to this example. So we have this LLC pass through to here if they're both disregarded and everything shows up on your 1040. So when you set up the LLCs, you have to choose how you want to have them taxed. And it really comes down to what is your motivation. Depends on the state in which you live in, what you want to disclose to your state. For example, if you live in California, LLCs in Oregon, Texas, Arizona, Florida, wherever they're doing their investing, and they choose to have them all disregarded. So nothing shows up from a tax return standpoint on their individual state return, because they know that if this entity here was set up as a partnership and produced a K1, California then is going to ask that they file $800 a year on this particular entity. That's the way California works. If you got an LLC set up, even if it's doing business out of state, they assert that it's doing business in California, and you have to pay $800 a year to have it. So, an audit? Absolutely. Given what the IRS has said and what they've done, you are going to be audited, or there's a strong likelihood that you will. So one of the goals in asset protection planning is to keep my clients from getting audited. Even if they would walk through it unscathed, it's no fun to be audited. I've been through them before. And I can tell you, the scariest part about an audit is a person auditing you doesn't understand what it is you do, doesn't understand real estate, doesn't understand. Then what occurs is that all of the income from all of these other companies that hold your rental real estate that are flowing into here, this will all show up on a 1065 tax return that will be filed for that company. This 1065 will give you what we call a K1. It will give you your share of the earnings generated from that entity. That K1 is attached to your return. It wipes out your Schedule E, doesn't show up there, takes you out of the audit risk pool. That's why I use partnerships many times for my holding companies, to ensure that my real estate investor clients are at the lowest risk of being audited. A lot of audits are started by how you prepare your tax return. This is my preferred structure. Now, we've covered where to set up your limited liability company, the different aspects of it, what's important in deciding where to create your structure. We've talked about how it will be taxed. We've also discussed the difference between member managed and manager managed LLC lawsuit. Structure me with 25. Okay, I'll do it. Now, other people, when we have that conversation, I talk to them about the reasonableness of their structuring. And I explain to them that when I'm looking at properties, what I'm really focusing on is the equity in the property. I'm looking at the type of property it is. Is it in a neighborhood where you need a shotgun to collect your rents, or is it in a higher income neighborhood where the tenant mows the lawn and keeps their property up for you? So you have to determine that as well when you're deciding how many properties I should put into one potential limited liability company. And I also look at how well the property cash flows. I mean, the last thing I'd probably want to do is take some of my best performing assets and put them with some of the least performing assets, even though I was doing it on an equity base. And what I mean by that is follows. Let's assume that an individual investor had 4 properties. And property number 1 had equity of $150,000. Remember, equity is the difference between what the property is worth and what you owe. It's that middle number right in there. That's how much you stand to lose in a lawsuit. All right, so property number 2 has $50,000 in equity. Property number 3 has $200,000 in equity. And property number 4, we'll just give it $100K in equity. That's the money that's coming in. That's the money you're using to invest in other properties. So this property is very important to you as a real estate investor. So what we might do here is look at the equity in the properties, looking at the income, and then make a determination as where we should group them. So in this particular example, I would probably take 2 and 4 and put the company. You could possibly even throw in 3 in there. If you threw in 3, then you would have $350,000 in total risk exposure. So your structure would look something like this. You would have an LLC here with 3 properties, and you'd have another LLC here with only 1 property. Divide these up, put 2 properties in each. But it really comes down to your personal risk tolerance level. I cannot make that decision for you. I can give you some ideas on how you'd want to structure these. But again, it's what do you feel comfortable with? Are you the price per person that wants to have 1 LLC per property? Great, you could do that. In fact, in a later series, I'll talk about the series Limited and Invest, because this investor thought that they could get. All right, so we've talked about how many property liability companies, but the next step is deeding them in. Now, there is some differences of opinion when it comes to how you put properties into limited liability companies. Let's assume that in my example right there, we have 2 LLCs set up, and we've got our properties down here, and we're going to put 2 per LLC. Do you just deed them in? Just like that. Some people would say yes, deed the properties in. And now you have protection because the properties are now taken out of your name. Well, I would tell you, be careful. Don't just deed them right in. If you have debt on that property, understand that when you deed the property from your name into the limited liability company, you risk the bank accelerating your note. That is, you violated the due on sale clause in your mortgage, and it gives the bank the right to call your notes due. If you have 10 residential mortgages, it's going to be difficult to get these refinanced with a new mortgage if they call your note due because you transfer the properties into an LLC and they find out about it. Now, I've heard attorneys tell me that they've never, ever heard of a situation where a real estate investor's note was called due by a bank when they transferred their property into an LLC. Well, that just goes to show you their experience in working with real estate investors. I've been working with real estate investors for 17 years, and I've seen it happen to real estate investors. Now, granted, there are those outliers out there where people are in situations where they forget to pay their mortgage, they are not insuring their property. Yeah, that's going to get the attention of the bank. But how about the situation where the bank has a insurer who comes in to spot check the mortgages they're writing, and they pull some mortgages and they find out, hey, the borrower doesn't own the property. The borrower has transferred the real estate into a limited liability company. In fact, the borrower transferred 10 properties into a limited liability company. That's a real story. It happened. Bank came after that borrower for transferring his property and called those notes due. Other situations, the bank goes to sell your mortgage. Now, people aren't just going to buy all the mortgages the bank has to offer. They're going to inspect those mortgages. If yours, the mortgage that gets inspected, they may find that you're no longer the owner. You put it into an LLC, so now the bank comes a-knocking. I'll give you one other reason why you should seriously consider before you transfer your property directly into an LLC, and that has to do with the importance of this acceleration clause. Interest rates, they're going up. And they're probably going to continue to rise. If you got a great interest rate on that house, do you want to jeopardize it? If I'm in your situation, I guarantee you I don't. I don't want to put myself in a situation where I could potentially lose it. Because from the bank standpoint, if interest rates rise 3, 4, 5, 6%, they have every incentive to go through their loans to find out if the owner or the borrower of the property is also the owner. If he's not, why not force that person out of that 4.5% mortgage and get him into a 10% mortgage? More money to be made there. So be careful. Now, what I would suggest you do, and what we've been doing for years here at Anderson, is that we don't transfer property directly into an LLC unless, get this, unless there's no debt on it. If the property is encumbered by debt, then what I want to use is a land trust. Okay? This is the entity that is going to prevent a bank from accelerating your note and allow you to transfer your real estate out of your name and into an LLC without alerting your lender to the fact there's been a transfer. In fact, if you set it up properly, you can actually obtain anonymity so people don't even know that this property is owned by the LLC. There's a lot that can be done with land trust to protect real estate. As I said, I've been doing it for 17 years. And I've had clients that have been in situations and lawsuits before and dealing with banks, and they have not a clue as to what's been going on with their real estate because nothing shows up on the public record other than the land trust. Nobody knows where they own it. This is a very important topic, and most real estate investors miss it. Well, you're not, because in one of the upcoming segments, I'm going to delve deep into the benefits of land trusts and show you how they can benefit you when it comes to real estate investing. You know, I hope you learned something today when it respect to limited liability companies and how you should set those entities up from an asset protection standpoint. We at Anderson work really hard to ensure that our clients' assets are protected, because what makes us unique that is different from local attorneys or these internet gurus who sell business entities is that not only are we a law firm, and we're also a tax firm. That is, we have both the tax and the legal in-house. We're also real estate investors. I flip properties, I own commercial real estate, and I own residential real estate. You know, if I haven't done the deal, I've got clients that have done the deal. And so we have a breadth of knowledge. There's a reason why we have over 50 employees in our company working with real estate investors just like you to ensure that their taxes are minimized, but their asset protection is maximized. And at the same time, it's compliant for real estate investing. These are things I'm going to be sharing with you in upcoming segments. My name is Clint Coons, managing partner of Anderson Business Advisors and Law Group. Feel free to give us a call, and we'll give you a free structure. We'll walk you through what you should be doing in your situation to ensure that your assets are protected. All the best. Take care.
What y'all think about that? Yes. That is Anderson Advisor, Clint Coons. And they're in Las Vegas, too. I know, my apologies on the buffering. They tripping. They was tripping on that. But hey, y'all need to understand that the importance. Now, when dealing with trust, and you're doing investing, it's going to show up as a C Corp on the public side. It's not going to be an LLC. Okay? And that is different. This is why I'm showing you the importance of holding companies. Like, I deal directly with holding companies and trust administration companies. And if you create business trust corporations, it's going to show up as a C corporation on the public side. You know, so like I can show you with the California business search. So like secured party credit. When you go look up Secured Party Credit, California Secretary of State, entity search, it shows up as a general stock corporation or a C corporation, right? But you got to see the incorporator is an actual trust. And when you deal with certificates and units within a trust on the public side, it's going to show up as shares. So I just want y'all to be mindful of that. So when dealing with investments, so to speak, I would do a C corporation or a trust corporation. Does that make sense? Also, I'll put a video in there of Waka Flocka. He breaking down. He been doing investments. Check that video out. There's some other videos of Anderson Cooper I think you should check out. To stay anonymous. This helps with not just your property, but just for your businesses altogether. So, and then, like if we go to Missouri business search, right? Now, Missouri, you don't have to pay a tax on your LLC. You do have to have a registered agent starting off, though. So we got that LLC right there. And then I'm pretty sure we got Don Kilam. Let me see. It might be Malik Kilam. Well, we had a fictitious name. And then dealing with our kids. So, you know, fictitious names are DBAs, right? And this would be owned. This is actually owned by the actual LLC. So that's how I do that one. But so I went over the 2 dispute letters next week. I want y'all to have this. I want y'all to have these LLCs set up. You need to have these set up before you go dispute, before you try to change the foreclosure, whatever it may be. Okay. Before you assess the tax, before you do anything. You gotta remember, the person assesses the tax, and then the corporation or the LLC is the one who's going to collect. You have to understand, we're going to expose the fraud, and you're the main investor. You want your proceeds. We're assessing the tax. That's what's going to happen next. So next week, if you want to read ahead, I'm going over this right here. What happens after the dispute letter, okay? Whatever they try to send, whatever it may be, what happens after the dispute letter. So we're going to go over every single letter next to the Department of Treasury, to the SEC, to the IRS, to the district courts, to the Secretary of State, and to the Attorney Generals, okay? These are the next letters because you've given them time. Make sure your LLC is set up. If you're actually utilizing this process. This is for mortgage and foreclosures alike, okay? Always address all parties involved. Let me know if there's any questions over today's information. Does everybody have access to the documents? So next week we're going to go over the rest of those letters, and then we'll go over reconveyances. Okay, how to start reconveying things. If you want to skip ahead, that's course 8 right here in private banking. Okay, we were still going over definitions, right? But we'll probably start right here. The solution. So we still have a lot to cover. But we're coming from everybody's following along. We're coming from a standpoint. I like coming from the standpoint as an AR, as a representative for your name, okay? You have one main holding company, and then underneath that you'll You'll just have minor businesses, whether it's consulting firms, business management firms, whatever it may be. Okay? Try to stay vague, but where you can obtain multiple assets. I like holding companies, business management, business consulting, trust administration. Okay? You follow me. Well, I'm going to call it a night. Prosperity is your birthright. You already know if you find this information valuable, what to do. If you're on the Instagram, you're on the Facebook, Cash App is Secured Party Credit. Make sure you hit like, subscribe, share. If you're in the class, you can describe. Do this for anybody. Someone asked, does this work for reverse mortgages? A mortgage is a mortgage-backed security. This works for all of them. It's all fraudulent. It's all fraud. We're exposing the fraud. If you're paying, you're an investor. They just don't tell you. So that's what it is. Now, one last thing before I go. I do want to show you this. Okay? A lot of people don't go over this. This is how you get your proceeds. Now, this is another way to make sure you get your proceeds, your dividends from any type of investments, whether it's a credit card, whether it's any type of loan, okay? A 1099 DIV. And you'll get up to 9 times the amount of the loan amount, okay? You get up to 9 times of the loan amount, whatever you're investing in. A 1099 DIV. Because once you learn about the investments, you are due dividends. So this is how you assess the tax. If you don't assess the tax, then everything is a gift. Okay? Because ignorance of the law is no excuse. So I'll dig a little deeper into this. Also, there's still time to sign up. You got to the end of January if you want to sign up for the hashtag BNB, Build My Business class, alright? We're going to go over different ways, different businesses, how to build it from scratch. You already see how stuff is coming together, alright? How to stay anonymous and protect and create assets. And then we'll make sure the business can build business credit, okay? But learn how to make a real business that makes 100K plus a year easily. You know, and we went over multiple businesses such as consulting, business management, bookkeeping. The list goes on and on. Copywriters, okay? Estate planning. Make sure you know what you want to sign up for that. And then we'll dig deep into this form right here. It's a 1099K. So anytime you're dealing with a third-party merchant such as Stripe, PayPal, this is how you got to know your ABCs, okay? It's a 1099K when dealing with Stripe, PayPal, Square, Cash App, any of those entities, okay? A 1099K. Payment card and third-party network transactions. This is how you file the taxes on those. This is for educational and informational purposes only. You want to make sure you follow along. So we'll dig deep into the 1099 DIVs later in the foreclosure class, the 1099Ks with the Build My Business class. Not only will we show you how to build your business, right? I'm going to show you how to market it, how to create it from scratch, create your personal credit, get it together, build your business credit, so you have no excuse. Protect your assets with a trust. That's what it's all about, man. Cash up $100, alright? Or go to donkilam.com, malikkalam.com. It's $500 there. And then it's going up to $2,000 after January. So, you don't want to miss it. Make it happen. Personal credit, restoration business, whatever it may be. Show you how to get certified. Become a power piece in this game. There's no excuse. The time is now to go get this, alright? Much peace and love. Yes, status correction class is still going on. We still got a couple weeks left to the end of January for the status correction class. That's $100 and you'll get access to the old classes, okay? So, make sure, if you send the Cash App, make sure, if it's Build My Business, hashtag BNB in your email address. If it's mortgage and foreclosure, make sure you put mortgage class or foreclosure class with your email address. If it's for status correction, make sure you put status correction and your email address in the memo box. With that, I'm out. Much peace and love. Check out the other videos. Prosperity is your birthright. Baby. Baby. Here. Here.
Now it's time for me to go see your phone, nigga.
Who cares? Who cares? Remember what I told you? Remember what I told you?
I do, nigga.
What I tell you though?
Look at my face.
What
I do.
What I tell you though?
Oh, what?
You go through my shit. And you gonna find out when you're done. Best believe you're gonna be working. There's plenty of work in there. Okay? Baby, I'm hot though.
You hot. I'm hot too.